Okay, let's talk about alternative approaches to dispute resolution. So we're going to talk about ways to resolve disputes in divorce litigation other than trial. So first, there's the tried and true old-timey negotiation. And I love how your book tries to tell you how to negotiate or settle a lawsuit. When it's really hard to tell somebody how to do that. I mean, it's really more or less something that you learn. And to be honest, it's something that some people never really get good at, and some people are natural at it. Um, we'll go through it, but anyway, your book says you can try to settle a case on the telephone, but it's better in person. That part is true. You're not going to settle a case on the telephone. Usually, usually cases are settled over time. They're not settled before discovery is done. Usually, you get to know the other lawyer, you do some discovery, you see what your case is worth, you see what their case is worth, they see what their case is worth, they see what your case is worth. Their client sees what your case is worth. They get used to the fact that their situation's not perfect either. And over time, if it's gonna settle, over time you get a little bit closer, a little bit closer, a little bit closer until finally you are able to settle it. Sometimes not until the day of trial. Usually, as the case goes along during discovery, you talk to your client. What is it that you want out of this? Not the moon, not if you had everything you ever wanted, what would you want? But what is it that what could what could you live with out of this case? And you start encouraging your client to think realistically about what they could live with. Because, most people go into a divorce thinking about every way in the world that they were done wrong and wanting every way in the world that they could be done right again. And the problem with that is that, you can't, there's a lot of things that happen in a marriage and in divorce that you can't fix with litigation. So you've got to help move your client to a point where, over time, where they can resolve their situation, hopefully. If you don't, then you're going to have to try your case and then let the judge force an order on them that they may or may not like. So usually, if possible, it's best if you can help them come to a realistic idea of something that they can live with. And obviously that would be in a negotiation situation or mediation. In Morgan County, not Madison or any other, but around here, but in Morgan County, it is mandatory that couples try to mediate their case before they're allowed to try it. And some people agree that that's a good thing. Some people don't. A lot of people who don't think that that's a good idea, one of their reasons is that they think that I see where they're coming from on this, is because that in a lot of couple situation there is a power imbalance. In some cases that goes as far as abuse, intimidation, and that mediation is not realistic or even helpful in that situation because they are not coming from equal standpoints. So, but in mediation, you have a third person who a mediator who helps couples reach their own agreement. I have a partner who's a mediator, and he's not an advocate. Mediator's not an advocate for either side, but rather helps guide the parties through a process of reaching agreement by helping them identify the important issues, consider what their options are, and to structure what is a realistic settlement for them. Divorce mediators don't have to be lawyers. Some of them are mental health professionals. Usually they come from one of the two fields. So let's talk about the mediation process. In stage one, usually, first of all, I know from doing mediations here in our law firm, usually the mediator tries to set up a very comfortable environment. Usually it's, soft music, comfortable furniture. I know that, one party and that party's lawyer is set up in one area, and the other party and their lawyer is set up in the whole other end of the building. And they're both in very comfortable areas so that they can talk and relax, and there's plenty of food and beverages, and because it's not necessarily a short process unless it quickly does not work. And if it is working, it can be a lengthy process. So anyway, that's how it is set up. And in stage one, the mediator encourages the parties to verbalize, say out loud why they have come to mediation and what their expectations and concerns and goals are. And then the mediator explains the process, including what his or her role is and what their responsibilities are as participants, including, their duty to participate in good faith. This is just not just a requirement, a hoop to jump through. I mean, this is something that you have to take part in good faith. The mediator will then explain the ground rules to the participants, such as confidentiality. And then there's a contract that they sign, a contract to mediate, which sets out the framework for the mediation, and it's usually signed by the couple and the mediator. And I will tell you that in order to be a mediator, you have to go to school for it. You have to go to training, and it's not just an hour. I mean, it's significant. So so that's the first part, and it's really to establish trust. It's not only an understanding of the process, but it's also to establish trust between the parties and the mediator. And for the mediator to explain to the parties that this is important, and I expect you to participate fully. If you're going to be in it, I expect you to be in it. If you're gonna participate and sign the contract, then we're going to do this together. So stage 2 is a fact-finding process. And generally during that time, the parties commit to a complete disclosure, and they provide copies of documents that would normally be requested in the course of discovery. It's not formal discovery, but they talk to the mediator about facts. They talk to the mediator about, they answer questions to the mediator about, factual concerns about issues in the divorce. It's not testimony, so there is the concern that, one spouse shares more than the other. Obviously, that is a concern of people who don't necessarily think that, mediation is the greatest thing in the world. But stage 3 is once the mediator is satisfied that he or she's gotten all the information out there that he or she can, then the mediator helps the parties identify what they see as the various options there are for them. And I think the most important part of that process is getting them out of this fixed idea of here's where we have to go. Helping them see all the available alternatives for them. Sometimes when at that point, couples have gotten into a rut of thinking it has to be this way or it has to be that way. And a mediator's job is helping them see other alternatives. And so then stage 4 is helping them go through those alternatives, just sorting through them. And at this point, the mediator usually tries to take a step back and lets the parties turn to their lawyers and look through those alternatives and see which ones, if any, are in their best interest, and see if they can come to an agreement on any of those. It's not uncommon. It's not uncommon at this point for them to ask questions of the mediator, whether ask legal advice, whether they think, whether the mediator thinks, is this option in their best interest? Is that option, do they think that option's fair for them? And it's a question really whether or not that is proper for a mediator to do that. Some mediators say yes, some say no. A further complication is where I'm sorry, got somebody trying to call me. Some mediators are more hands-off, and some mediators are more activist, are more hands-on, trying to guide them. Yes, I think that would be in your best interest, or no, I think you could ask for more. I think you could get more from that. Once a settlement is reached, then the mediator may or may not be the one to draft the settlement agreement that embodies the parties' understanding. Obviously, and then the agreement will have to be, closely scrutinized to make sure that that's what the parties agreed to. Your book says that e-mediation is becoming an integral part of effective and affordable divorce mediation services and programs. I know that people, especially right now, with everybody doing everything on Zoom, including court hearings and church and conference, everything conference, and well, we're doing this by video. But, one of the real reasons why mediation works is because you're so able to work hands-on and evaluate another person face to face, and to see their reactions and to evaluate their emotional responses face to face. So that when you are presenting them with options, when you are asking their responses, you can actually evaluate those face to face. Now, I know that people do telehealth. I know they do all that. I know they do that with psychologists and psychiatrists. I know they do that. But I also think that that's probably second best to face. I'm glad that people have it when they can't have it face to face. And I'm sure that it's much more cost effective than maybe getting everybody all in the same place. But I think that it would be much less effective because and your book says this, it says one important consideration is that while distance may offer some benefits, the lack of warmth, empathy, immediacy, rapport, and other attitudes and affects that make face-to-face mediation what it is are clearly missing from this process. And that is so true. There's something about face-to-face communication that makes mediation work. And I'm just not sure that I just don't think that would be available over the internet. So if it's your only option, I think that would be good. But I don't know that it would. Mediation doesn't always work anyway. Even face to face, you don't always settle your case. So I think you would probably settle it even less of the time if it was over the video. But let me just share something with you that I forgot to share with you when we were talking about negotiations. I wrote it in my book. Negotiations. Yeah. Most cases settle. In fact, I think in 2018, no, wait, that's appeals. Okay, we'll get to that in a minute. Sorry. Okay. Arbitration. No, we don't do arbitration in divorce in Alabama, so we're just going to skip over that. Okay, we can briefly talk about the collaborative divorce approach. We don't. I'll talk about that. No, let's go on. Let's move on to unbundled legal services. You may have a client approach you who cannot afford to hire you for an entire divorce. And it may be that they are trying to handle their divorce, what's called pro se, meaning on their own. And but they need help with a particular aspect of the divorce. So in that case, they would be seeking limited assistance for a particular thing. Like, So in that case, we would go from looking at, helping, from the very beginning to the very end, to just coming in for a very limited scope. The problem with that, as I see it, is, and it's not that I wouldn't be willing to do that. The problem with that is that I would be concerned that that they would not, that client would not understand where I was leaving off when I finished. So if they came to me and they said, I would like for you to draft an answer for me. And so I did. I would be concerned that they did not fully understand that what they needed to do after that, and that I no longer would be doing anything for them after that. And, it would be important at that point that it would be important in that situation for one to draft a very clear and concise contract with that person that very clearly stated what you were doing for them and what you were not doing for them, so that hopefully so that they would understand, and also so that you wouldn't have any liability in that situation, for any misunderstanding on their part. Okay, so let's look at page 508. Reaching resolution, the separation agreement. So, assuming that you reach an agreement, somebody's got to write it up. And yeah, it sounds like extra work, but really it's actually in your best interest to be the one to draft the settlement agreement, because even though you might agree on, the big things, there's always a few things that you don't think of. And so if you're the one to draft the settlement agreement, then you can always just throw in the extras. And chances are that by the time the deed is done, it may be that they just go along with some of them. So, when you draft the settlement agreement, you will draft it, and hopefully you'll have a good paralegal, like all of y'all, that you can rely on to take a look at what you've agreed to and do a draft of a settlement agreement, and then and bring it to you. And then you will take a look at it and, do corrections. And then when you get a good draft, then you will send it over to the other side. They will look at it and they will make some revisions. They'll send it back to you. You'll make some revisions, then you'll send it back. And then eventually you'll come to an agreement as to the one that you both have agreed to. And you'll also do a proposed order, one that's based on the settlement agreement that you both are okay with, and it's a draft order for the judge to sign, and that is what you will file. A settlement agreement, a separation agreement is basically nothing other than a contract. It's a divorce agreement, a divorce contract. And most of the time, most offices start with a standard form, and they go from there to use the standard language, and then they use that to create a unique document for each particular case. On page 510, there's a sample separation agreement. Your office, though, will have its own. There will be, especially if you do if you do mostly family law, but if you do any family law, your office will have a million of them. So, and there'll be ones that have child custody and visitation, and ones that are mainly just divorce, and ones with both, and ones with 2 kids and 3 kids and 1 kid and dogs, and there'll be all kinds to look at. So, when you get there, just take some time to look around in the computer, and you can look at all of them to see what they look like, and how your firm normally does them. This goes on forever. All right, so let's move on to page 526. So in a divorce hearing, the court, if the couple is presenting in an uncontested hearing,